Hello, class, and welcome to this week's lecture. We are going to be talking about contracts, and a very important part of contracts is offer and acceptance. Okay, so what we're going to do is I'm going to kind of go through it. I have the book in front of me, but as I go, I don't, as you know, I don't like to just read directly from the book. I want you guys to kind of understand it as we were just having a conversation. So let's start with offer and acceptance. So this is what happens is anytime there's a contract, there has to be an offer. Okay, so an offer is defined as an expression of the offeror's willingness to enter into a contractual agreement. Okay, so it has to be clear and definite. It can't just be illusory, is the legal term. So if I'm making an offer, I would say I offer to sell you my car for $5,000. Okay. Or if I'm in the restaurant business and you walk up to my restaurant, you say, "How much is a hamburger?" Well, that's not an offer. I just asked you how much a hamburger was. Where the car example was an offer. Would you like to buy my car for $5,000? It's much different than how much is a hamburger. Okay, so you see the difference there is it takes a certain amount of definiteness when we're talking about an offer. So, as we begin, offer. So, an offer is the offeror, that's the original person, willingness to enter into contractual agreement. So, what we call the other style, where it's like, how much is your hamburger? We call that an invitation to offer. Okay, so I'm like, hey, how much is a hamburger? And then you, the restaurant owner, say a hamburger is $5. Would you like one? You, the restaurant owner, made the offer. Do you see? So I made the invitation to allow you to make an offer, then you physically made that offer. And then whether I accept or not, well, I mean, obviously that depends on whether I want your hamburger for $5 or not. So offer, we want to make sure we know this word. It requires definite terms, okay? Definite and certain terms. So what we want to be able to do is make sure that we don't use illusory terms that can't clearly be defined. Like, I don't want to say to you in the restaurant example, I say, how much is your hamburger? And then you say, it's a good price. Would you like one? Well, that's not really definite. What the heck is a good price? So we want definite terms whenever we're forming a contract. I'm going to read you guys a little case here, and it's short. I don't like reading a bunch of cases all the time, but kind of give us an example of how all of this ties in together. So, the facts. Larry made an oral contract with Hubert to restore a 1963 Chevy Impala convertible. The car was not in good condition. Hubert advised the owner that the work would not yield a car of show quality because of the condition of the body, and accordingly he believed that the owner merely wanted a presentable car. Larry, on the other hand, having told Hubert he wanted a damn good job, thought this statement would yield a car that would be competitive in small amateur car shows he attended. When the finished car had what Larry asserted were waves in the paint as a result of an uneven surface on the body, Larry brought suit against Hubert for breach of oral contract. There was clearly a misunderstanding between the parties over the quality of work that could and would be obtained. Quality is a material term between the parties on which no one understood what those words meant. Accordingly, a court will not find an individual in breach of a term of a contract where the term did not exist. So this is what they said. This is, hey, I want this car, and I want you to fix my Chevy. And the guy says, well, it's not that nice, but I'll do a damn good job. And you think of that as, okay, it's going to be nice. You get it, and it's not nice. Well, we use the term good job. That's not what we need. We need to get definite in our terms. So these gentlemen, they should have discussed, something like, in classic cars, I actually know this because I have a legal case revolving around it, is classic cars actually have a scale. okay, like a 1 to 10 scale. And that would have been an example of your car when finished will be a 8 on the blah blah scale, or a 9 on the blah blah scale. And then you have it, and if they don't agree, then you have it appraised by a collective car person, and they tell us what the scale number is, and then we know. But you got to have something definite, and they had nothing definite, just words that were just good job. That's not going to fly. So what we need to understand is that if you don't have definite terms, it's hard for a court to enforce your contract, okay? So we want to make sure that we know that we need definite terms all the time. Now, sometimes whenever we make an offer, okay, we need to get that acceptance, right? So I say to you, I would like to sell you my hamburger for $5. Now what I need for you to do is give me an affirmative yes, okay? Not a not a none of that stuff. I need a verbal yes, or a verbal no, or some type of action that indicates a clear acceptance of the term. Like you hand me $5. So if I say I'll sell you the hamburger for $5 and you hand me $5, well, we got ourselves a contract. However, if I say I'll sell you the hamburger for $5 and you hand me $4, okay, we don't have a contract because it wasn't your acceptance was not a clear reflection, a mirror image of my offer. Okay, so you got to make sure that that they are very, very much reciprocal in nature. So what we say is what they do. Now, there are two types of contracts I want everyone to make sure that they understand the difference of. And I'm actually highlighting them in my little notes here. One is called a requirements contract, and one is called an outputs contract, okay? So a requirements contract, this happens a lot in the food and beverage industry, is a contract to buy all the requirements of the buyer from the seller. That's a requirement. An output is to sell the entire production of output to a buyer. So, you're a cake salesman, okay? I own a restaurant, hotel, it doesn't matter. And I say to you, I want to buy all of your key lime pies because I want to have all of them. I don't want anyone to be able to buy key lime pie that you make from anywhere but my restaurant, okay? That is an output contract. I'm asking for all, okay? A requirements contract is a little different. I'm only asking to buy the key lime pies that I need. I'm not telling you a particular number. I'm not saying that I want 20 or I want 30 or I want 50 or I want 100. I am telling you I contract you for every one that I need. So if I sell 10 this week, I need 10 more next week. If I sell 1,000 next week, I need 1,000 next week. And you know that I'm asking for all the requirements I need. That's a requirements contract. An output contract is I want all of your inventory. If you just make one, I get one. I'm not telling you that I need 1,000. I'm just telling you I need all of them. So you need to make sure you understand that. That's kind of an important one in the business world is requirements and output. And that's the thing where we talk about the offer is I want to buy all your cakes. That's an output contract. Okay. If I say I want to buy all the cakes I need, that's a requirements contract. Okay. So then the acceptance comes from the baker, who either gives the affirmative yes or the affirmative, or the disaffirms by no. So know those two. All right, terminating an offer. An offeree cannot accept a terminated offer. Offers may be terminated by these ways, and I would know these ways. These are highly tested, okay? By revocation. So what is revocation? Revocation is saying no. So if I say, I would like to buy all of your key lime pies, and you say, and you don't say anything, and then I say, I changed my mind. No, I don't want your key lime pies. Before you say yes, that's a revocation. I've revocated the offer, okay? I took it away before you accepted. The next is a counteroffer. So if I say to you, I want to buy all of your key lime pies, and for $5 a piece, and you say, ooh, I will sell you all my key lime pies, but for $7 a piece. Okay, and I say no. No. Then you can't just say, the baker can't just say, oh, I'll take the $5 then. Once you counteroffer, the original offer is no longer on the table. So let's just kind of play that out a little bit. So let's talk about the pies. You're the baker. I'm the hotel. I want to buy these pies from my hotel. And I would like to buy 10 pies, okay, every Friday for pie night. And I would like to pay $5 per pie, okay? And you look at me and say, I will provide 10 pies, but they must be $7 a piece. And then I, the hotel owner, say, no, thank you. You can't then say, yes, I will take the $5. I changed my mind. It's over. Once you made the counteroffer and changed the terms to $7, the offer's dead, okay? The original offer. Now I, the hotel, can be like, okay, no problem. I kind of won the negotiation. I wanted $5. But see, you've made a counteroffer of the 7, and I said no. And then you made another offer saying, I will do the $5 deal. Then I accept. Okay, so that's kind of how that works. Next is rejection. Obviously, if I say I want 10 pies every Friday night, $5 a pie, and you say no, that's rejection. It's over. Lapse of time. So I say I need pies Friday. $5 a piece, need 10 of them. Saturday comes around. You can't say, I'll take that deal, here's your pies. Well, time's lapsed. I needed the pies by Friday. So it's over. Death. So I offer to you, I'd like to buy the pies, $5, 10 pies. And before you say yes, I die. Well, you can't accept an offer once I'm dead. It dies with me. Okay? Next one, disability of a party. That is normally done through incapacitation, such as somebody's in a coma. Not dead, but I'm incapacitated, or I get dementia, or whatever the case may be. I have amnesia from a car accident, doesn't matter. But some type of disability before you've accepted, okay? Makes an offer go away. And the final one is illegality. Subsequent illegality, actually. So, because there never was a legitimate offer if it's illegal. However, subsequent illegality can happen. Here's an example. I would like to buy 10 key lime pies, $5 a piece every Friday, okay? And I say this on Monday. And you say, let me think about it. I need a couple days. No problem. I'll give you till Wednesday at noon. Tuesday comes. They pass a law banning the sale of pie to curb obesity. Okay? It's now illegal to buy pie. Well, my offer goes away. You can't be like, oh crap, I'll take your offer because I have all these pies, now I can sell them. No, subsequent illegality states that the offer is off the table. So those are the ones. So let's go through them. Revocation, counteroffer, rejection, lapse of time, death, disability, or subsequent illegality. You'll want to make sure that you know those for sure. Revocation of offer, we kind of went over that, but it's got to be clear. So revocation is where I'm the offerer and I say I'll sell the pies for $5. I got to tell you the offer's off the table. Like I got to be like, I changed my mind. It's no longer valid. Okay, I can't just be silent in my revocation. I need to actually, say it. As we go forward. Now. So as we kind of talk about counteroffer, okay? So it's that whole thing where I said $5, you said $7, now my offer's off the table. I'm going to read you a short case again. Kind of talks about it just so we can kind of hedge it out a little bit. While riding her motorcycle, Amy was struck by a vehicle driven by Brown. She suffered serious injuries and Brown was charged with DUI. Amy sent a demand letter to Brown's insurance claims administrator statewide, which stated in part, please send all insurance money that Mr. Brown had under his insurance policy. In exchange, I will agree to sign a limited release. The release must not have any language saying that I will have to pay Mr. Brown or his insurance company any of their incurred costs. If you fail to meet my demand, I will be forced to hire an attorney and sue Mr. Brown and your company. Please do not contact me or my friends, as this demand is very simple. Statewide sent a letter to Kemper agreeing to settle her claims for the limits of Brown's liability policy. Attached to the letter was a check for $25,000 and a 2-page limited liability release form. The letter stated in part, concluding the settlement, we are entrusting that you place the money in an escrow account in regards to any and all liens pending. This demand is being asserted to protect the lien's interest. Mr. Kemper, Amy, rejected Statewide's counteroffer and filed suit. Brown filed a motion to enforce the settlement agreement. The court decided for Miss Amy, and the court said, hey, she told you free and clear. She didn't, so your acceptance was not the mirror image of the offer. So you can't throw things in there, okay? Or the settlement is no good. The offer is no good. It's gone. The counter offer, as soon as you said you had to keep money in an escrow account for any liens, over. Because she distinctively said free and clear of everything. His entire limits, free and clear of everything. If it's not the mirror image, it's a rejection. Offers off the table. So just to kind of show you what happens in real world, examples of way things go. Now, silence as acceptance. Now, normally when we accept an offer, okay, silence won't do. But we kind of talked about it earlier when we said, hey, I asked you the hamburger $5, you hand me $5. That is acceptance. You need an action. You need an overt action, okay? However, an offeror can require the offeree, which would be the person accepting the offer, to give an affirmative response or to put it in writing. So I can say to you, I would sell you my hotel for $1 million. And this offer is good for 72 hours. To accept this offer, you must sign, this contract and send it by certified mail, timestamped within 72 hours. And you call me on the phone and say, I'll take it. You didn't take it because my offer indicated how you accept it. So the offeror can basically dictate how the acceptance is done. The offeror has all the power at the end of the day. So if they say it must be in writing, well, then you got to put it in writing. You can't just do it your way. You got to do it how the offeror says. All right, we are going to talk about the mailbox rule. Mailbox rule is super fun. So what the mailbox rule states is that acceptance is achieved upon it being mailed, not upon receipt, okay? So I say to you, I will sell you my hotel for $1 million. And I don't say it has to be in mail. I don't say it has to be in writing. I don't say you got to speak it. I just say I will sell you my hotel for $1 million. And you accept it. You're right. I accept your hotel sale for $1 million. Here's a certified check, and I put it in the mail, okay? While it's in the mail, I decide, I don't want to sell this thing. I haven't got your acceptance. I ain't got your check. I ain't got nothing from you. I call you up and I say, hey, I'm going to revoke the offer. I don't want to sell my hotel. And you say I already mailed a check. You've accepted the contract, and I must sell my hotel for the $1 million, okay? So that's what the mailbox rule says, is that as soon as the acceptance is placed in the mail, okay? The moment it's in the mail, acceptance is done. I'm going to read you a very, very short case, okay? But this is the case on point. This happened in Florida. Appellate case of Florida in 1963. It's good law today. It can be argued in court right now, okay? If you're in the right appellate district. So, the Tholts owned a land, okay? The Morrisons mailed an offer to the Tholts to buy their land. The Tholts agreed to this offer and mailed back a contract signed by them. While the letter was in transit, the Tholts notified the Morrisons that their acceptance was revoked. Were the Tholts bound by a contract? So, think about this. Let's go back to our hotel thing. This is the same thing that happens here. I say to you, I want to sell you my hotel for $1 million. Okay, it's Monday. On Tuesday, you mail me $1 million with a signed contract. Okay? On Wednesday, you change your mind and you call me and say, hey, I am out on the whole hotel thing. It's over. This is Wednesday morning. I'm out. Then Wednesday afternoon, the mail arrives to me with your signed contract and your $1 million. We have a contract, is what this case is saying. It's saying that the moment you put that mail in the mailbox, it's over. And it's fair, because this is what happens is if I'm selling the hotel for $1 million and you put the check in the mail on Tuesday, and then I call you on Wednesday morning, I'm like, I'm out. Well, you have a contract because you mailed it on Tuesday, okay? Same thing though. You can't have your cake and eat it too, in the sense that I can't say to you, hey, $1 million from a hotel on Monday, Tuesday you send me the check, and then Wednesday you call me and revoke. You can't have it both ways. Once the mailbox door shuts, they actually call it when the mailbox bangs shut, we have a contract. That's the way it works with acceptance, okay? So it's very important that you kind of know the mailbox rule. It's likely to be tested on your exam. It's a fun little, a type of thing to test. And the final one we'll kind of talk about today is anytime you're buying something auction-based, okay? And this is, and I'm not trying to get into any online thing. I'm just talking in general. Every company is a little different, but in general, auctions are invitations, not offers. So, if you're at like an auction to buy restaurant equipment, okay, and there's all these stoves and walk-in freezers, and the auctioneer is like, I'll take $100, $100, $150, $100, $200, $250, $250, $300, $300, $350, $300, $400, and then you're the last guy at $400, right? And the seller doesn't want to sell it for $400 because it's worth $4,000. He doesn't have to. The only way he has to is that he announces prior that they're selling it regardless of what the bid is. Now, some companies, like online companies, require that. Like there's a contract between the person selling and the person buying that says whatever it brings, it sells for. If it's 1 penny, it sells. But most auctions are invitations to offers, okay? So what I would do is I advise you guys look through your book, kind of read through offer and acceptance, look at some of the cases that are in there. But the basic idea, the takeaway that you really need to know is, when we go back to it, is offer needs to be definite. Like we need to actually have the terms, out there. Like we really want to make sure that we understand that. The next thing we want to know are the different ways in which an offer can be, taken away. So terminated is the correct use of the word. So revocation, counteroffer, rejection, lapse of time, death, disability, subsequent illegality. I also want to make sure you guys understand the different requirement contracts. Means what I need. Output means I get it all. Contracts, that is highly tested. That's very, very important inside of our business world. The mailbox rule. Put it in the mailbox for acceptance. As soon as you bang the door shut on that mailbox, it's accepted. So that's it for this lecture, and we will see you next time.